Winding down. They're just getting started. This is South Coast Tonight with Chris McCarthy and Marcus Farrow. They've got you covered on all the news of the day, from local issues to politics on both sides of the aisle. This is the place where the movers and shakers come to be heard, to listen, and where they're held accountable. This is South Coast Tonight on WBSM.
Welcome back to the program. I'm Marcus. 508-996-0500 is how you can get on the program. So I want to thank my guests. We're in the last hour. We've got open phone lines if you want to give us a call, 508-996-0500. Also taking messages on the WBSM app chat. Interestingly enough, when I had Sheriff-elect Heroux on yesterday, you know, when I had him on during the campaign, when I had Hodgson on during the campaign, the phone lines went nonstop, and I couldn't pay attention to the app chat. But I've found that when we had Sheriff Heroux on, we had a ton of app chat messages asking Sheriff-elect Heroux a question. So that's the medium that people prefer to communicate, and that's fine too. So I'm looking at the app chat now, and we had Not the Other Dan say something very nice about the show and said, that he's heard it's from the locals, that it's doing great. And I really appreciate that, Dan. Not Bad in Oak Bluff said, Tim, the South Coast Tonight app chat label hasn't listed. So, I'm seeing it in general message. I guess that's something, if Tim's listening, can figure out. If not, he'll see it tomorrow when he's on the Tim Weisberg show every morning, 9 to noon. But, I guess I just want to thank Donna Buckley, first of all, Barnstable County Sheriff elect. She won the seat that previously held by a Republican in Barnstable County. It was vacated, but she won the open election along with the DA over there, Rob Gallibois, who I had on as well. And I want to thank Leon Corey. A really interesting conversation, talking about his campaign, his experiences as campaigning as a black man in a small town, in small town politics, and his, what it means to him. And it's really cool. The podcast is up, or it should be up soon. I just hit upload, so it should be up soon if you want to check it out. If you missed something, if you want to go back, if you want to listen to older episodes, the podcast is there, I guess. And, we'll take your calls and app chat messages for the remainder of the hour. The one thing I did want to talk about, I'd gotten this notification like pretty much just before I went on the air, and I wanted to talk about it, but I thought this was a good hour, as a free hour that we could talk about it. It is the Senate passed a bill that essentially recognizes same-sex marriage. So it is called the Respect for Marriage Act. And it's supposed to be there as a backstop, essentially, to recognize same-sex marriage and interracial marriage as a legally protected, basically because of fear that the Supreme Court may overturn some of that marriage precedent. The reason there were 12 Republicans that voted for it, so it was 61-36, I think, total. 12 Republicans voted for it. Of course, Senate bills, because of the filibuster and all that stupid stuff. Basically, when it's not a bill that has to do with the budget, that can be passed during reconciliation, and reconciliation is decided by the Senate parliamentarian. I can get into that. I could get into a whole thing about the Senate parliamentarian, but basically, if a bill is recognized as having something to do with, or having a substantial amount to do with the budget, such as ARPA, for example, it only requires 51 votes. And so a lot of that had to do with, Kamala Harris needing to be the tie-breaking vote and all of that. But basically, so it needed those 12 Republicans that got it. And basically, it's recognizing same-sex and interracial marriage as protected under federal law, which I think is important. Because what a lot of people, the Dobbs decision that overturned Roe v. Wade, essentially, Clarence Thomas, there's a 2015 Supreme Court decision, if you'll remember, that recognized same-sex marriage as protected. It was a 5-4 decision. Basically, it's a substantive due process decision. And it was the deciding vote was Anthony Kennedy, who had decided 2 years earlier in 2013 to strike the provision in DOMA, the Federal Defense of Marriage Act in the mid-'90s that was passed by the Newt Gingrich Congress but signed by President Clinton, that had said marriage is between a man and a woman. So basically, they struck that down, and then Scalia, Antonin Scalia, famous conservative jurist, Reagan appointee, had died in 2016, had basically said, well, this can be a roadmap. This can be a roadmap to legalizing same-sex marriage and recognizing it as the law of the land, and this is how, based on this logic. And so it was then cited basically by a lot of lower federal courts lower state courts that had overturned anti-gay marriage laws and had cited Scalia's reasoning, ironically, right? But then in 2015, it became legal again. I think it was a 5-4 decision. Roberts was a dissenter in that, but it was in a way that he was like more sympathetic to the movement and recognizing the rights, but said, well, I don't agree with the precedent of how this is done. I don't agree with the court doing this, which I think is a load of BS. But I think if they needed that fifth vote, I get the feeling that Roberts would have moved over into that column and voted to recognize same-sex marriage. I think he had some cover with Anthony Kennedy there. Anthony Kennedy famously was seen as sort of a more purple jurist, someone that will vote with conservatives and liberals sometimes, but I think a lot of that's misguided. I think he'd, on social issues, he's more likely to be liberal. On mostly everything else, he was a solid Republican vote, but he retired. So when the Dobbs decision came down, the overturning Roe v. Wade, Clarence Thomas had said, basically based on substantive due process, which was the jurisprudence, the court standard, that recognized a lot of fundamental rights with respect to discrimination, the rights of people of color, the rights of LGBTQ people in the community, the rights of women, gender equality issues. When they basically upended that in this Roe v. Wade overturning, Clarence Thomas invited it. The Supreme Court does this sometimes. They will signal to people in the Federalist Society or lower courts or basically conservative attorneys or conservative activist legal organizations to challenge these decisions. And one of them he listed was, and I believe it's the Obergefell decision in 2015 that made gay marriage the law of the land. He's basically signaled, hey, we can overturn this, and we will if you bring it to us. That's what he was doing. He was inviting them to do that. He said the court should revisit it if it comes up before them. And if you don't know the process, and basically if you petition something to go through the Supreme Court, it's a petition for cert, right? Writ of certiorari. I never got the pronunciation of that right, even when I was in law school. The writ of certiorari, basically. And you only need 4 votes to grant the petition to cert. So not a majority, right? Just 4 votes. 4 of the 9 justices need to vote affirmatively to hear the case. And, usually, if they hear a case like that, a case like those, if they're voting to hear it, they have ideas of how they're going to rule. They're not like, oh, let's, I want to think about this a bit. They know what they think about this stuff, the Supreme Court. They've thought about it for a long time. You might be able to convince them on some more arcane type of laws. You might be able to convince them one way or the other. But with stuff like social issues, like marriage equality, like the Constitution, all of that, they have a pretty good idea of what they think about it and how they're going to rule. But they have the arguments. Clarence Thomas actually famously doesn't speak in. He doesn't speak. He's spoken once or twice in the last 20-something years. Doesn't ask questions during oral arguments. Some people think, oh my God, what a tragedy. But in a lot of cases, I don't necessarily, those questions don't matter. Those questions are basically to get on the record what they think about this decision and basically signal how they may rule. The oral argument part of the Supreme Court decision making. So if they're asking you, if a justice is asking a question, I can't read their mind. I can't tell you why, but it seems to me if they're asking questions that seem critical or maybe even supportive, right? It's a signal of how they're going to go, and it's basically getting on the record what they think. Getting on the record what they think and how they're going to rule and the reasonings behind it. They're already getting that on the record ahead of the time before they're going to rule. So there's concern, obviously. That substantive due process is basically going to be, as it stands, it's already been basically null and void. Now, this brings up a lot of civil rights cases, the Warren Court decisions, Brown v. Board of Education, for example, Loving v. Virginia, which is a 1967 Supreme Court ruling that said you can't discriminate on interracial marriages, right? It brings a lot of it into question. Now, Sam Alito had said, oh, no, we like those, right? Those are different, right? But it wasn't really, the thing is that the thing that the conservative justices really have to reconcile, honestly, is that their core movement, the Federalist Society movement and the movement for originalism, textualism, all of that, was a reaction to the civil rights movement. It was a reaction not even against the civil rights movement. And so they have to square that circle on decisions like the Dobbs decision and say, well, those are different. And they don't really, based on their logic, present a compelling reason why. So it's concerning, right? And then you have the Colorado shooting at the nightclub, the LGBTQ nightclub. There's another one in Orlando. I remember, we had over here in New Bedford, we had Jake Robida, right, who had went into the Puzzles nightclub, the gay bar in the North End, and had not killed anybody there. It had eventually killed, I think, an Arkansas state trooper, in his flight away from that incident, but I'd went in there with a pistol and a hatchet and started hurting people. So there's a lot of concern around that, a lot of concern around the protections that have been in place based on, I think a pretty, I would say accelerated movement for marriage equality, right? They had at breakneck speed all of a sudden, quicker than a lot of other protected groups had, secured a great deal of rights. There was that 6-3 decision, or Gorsuch, I think, wrote a majority that said that they were protected, that gays were protected in the Civil Rights Act against certain employment discriminations. So they wanted to codify this into law. They wanted to make sure that gay marriage was a law that was passed, that was the law of the land, and that there would be basically a backstop if they wanted to overturn the Supreme Court, if they want to overturn the Supreme Court precedent that recognized marriage equality as the law of the land. They want to have that written so that they have that to fall back on. Now, the Supreme Court could, theoretically, because they can do whatever they want. It's one of the unfortunate kind of unfortunate features of the Supreme Court, that they're more or less seen as a de facto legislature. And that's an opinion that's held by conservatives and liberals based on however the Supreme Court rules. Donald Trump said it. These are activist judges when they ruled against some of his immigration policies, right? Like the Muslim ban and stuff like that. I think they eventually upheld the Muslim ban, but they first didn't. Some of his immigration policies, he said it. Joe Biden said it when they overturned Dobbs and other Supreme Court decisions that were unfavorable. And they're both correct, honestly, on that. The Supreme Court, unfortunately, in a lot of situations, has kind of been a de facto legislature. They have, there's a reason why these appointments have become political. It's because they are. I mean, John Roberts famously said, we don't, we just call balls and strikes. That was what he said in his hearing when he was nominated by President Bush. He was nominated by President Bush to become the Chief Justice of the Supreme Court. And that was after Rehnquist had died. Rehnquist had died in 2005. And Alito was already, Alito might have already been, no, Roberts was nominated, then Alito was nominated after Rehnquist died. I believe Roberts was to fill Sandra Day O'Connor's seat, and Sandra Day O'Connor was the first woman Supreme Court justice who was nominated by Reagan. It was one of the promises Reagan made during his campaign trail that he was going to nominate the first woman Supreme Court justice. It took till 1980, right? It took 200 years. But that was one of his main campaign promises. And when there was an opening in the early 80s, Sandra Day O'Connor was nominated. That was filled by Samuel Alito. And then John Roberts was put there to fill the Chief Justice seat that had been vacated by Rehnquist. I believe Rehnquist was a Ford or Nixon appointee. I think he was a Ford or Nixon appointee. He was like assistant solicitor. He was like the assistant solicitor general or something like that. The question is whether or not he was qualified for the seat, but he got nominated. Then he moved to Supreme Court Justice. Then he moved to he was nominated for Chief Justice afterwards. So anyway, Roberts said we famously call balls and strikes. Nobody really believes that. I think Roberts, in a lot of cases, is conscious of the fact that it is seen as the Roberts court, right? There's the Warren court, right, and the Rehnquist court, and now it's the Roberts court. So a lot of that stuff is part of his legacy. It has his name on it. So it's one of the reasons it's one of the reasons a lot of people say that he voted an affirmative to uphold Obamacare 5-4, right? He did that because he was conscious of it being his court and overturning that law, right? After a very popularly elected president and an overwhelming majority Democratic Congress had voted for it, and knowing that people really want health care and how bad health care is, he knew that it would reflect poorly on his legacy as the Chief Justice of the Supreme Court if he had overturned it. So there's reason to believe that Roberts would be a sympathetic vote for marriage equality now, but that still leaves, and maybe Gorsuch, but that still leaves, you still have Amy Coney Barrett, you still have Brett Kavanaugh, who has ruled consistently against LGBTQ cases. You still have Clarence Thomas, who's basically said, come bring this before us. We're gonna overturn it. And you still have Samuel Alito, who wrote the Dobbs decision, who was the key author in the Dobbs decision to overturn Roe v. Wade. So the Senate decided, they've got a lame duck session. The Republicans are going to have the gavel. No matter how thin or large the majority is, they're not going to get this passed, basically, when Kevin McCarthy has that gavel, because it won't even hit the House floor, probably. So they want to get this to President Biden's desk in the lame duck session. Lame duck session, for people who might not know, is basically the session in between elections and inaugurations. So this is a lame duck session for this Congress because the election's already happened. There's going to be a new Congress getting sworn in on January 3rd. And they, what they're trying to do, and a lot of people do this in the lame duck session, is try to get laws passed, basically, that wouldn't be passed in the next session based on the change of presidents, the change of the executive branch, based on the change of the legislative branch. One of the reasonings they give, one of the reasonings that the state legislature here in Beacon Hill in Massachusetts gives for having these long breaks in the informal sessions and all of that during an election year, during every 2 years or so, is because of the concern of lame duck sessions. And, basically, because you had in Wisconsin, when Tony Evers took over, I think he beat Scott Walker. The Wisconsin legislature and the governor had essentially had solidified these, hyper gerrymandered districts and had tied Tony Evers' hands and all of that. And so that's kind of little bit off topic, but they're trying to get this passed in the lame duck session before Kevin McCarthy takes the speakership. I think it's important to do. I think it's a good thing to do, too, to show that they, are actually going to do something about some of these issues that they campaign on all the time. But we're going to take your calls at 508-996-0500. Good evening.
Hi, Marcus. I've got a question for you.
Sure.
This Marriage Act.
Yeah.
I thought interracial marriages was, legal a long time ago.
So it is.
I mean, I get the gay marriage is, maybe 2000s, but I thought the interracial marriage thing was approved of a long time ago.
So what happened was in 1967, interracial there were laws in the books, obviously, against interracial marriage for the first.
Yeah.
In 1967, the Supreme Court said those laws are illegal. Those laws are violate the Constitution, and the precedent that they used was called substantive due process. But the problem is they essentially changed the entire. They changed substantive due process when they overturned Roe v. Wade. So they said the legal precedent that they used for Roe v. Wade, based on that, they could overturn Loving v. Virginia. They wouldn't necessarily, but they want to protect it just in case, because they're saying there's no safeguard now. There's no. It was based on Supreme Court precedent. The Supreme Court had basically overturn that precedent or could overturn that precedent. So they want to protect it. Now, do I think this Supreme Court, as it's currently constructed, would overturn an interracial marriage? No. But the thing is that they could and they might at some point in the future, and they want to have a law on the books that protects it.
Oh, okay. I see now. I was like, why are they bringing interracial marriage with the gay marriage?
Well,
I just
the other reason
that was been legal for a while now. I didn't realize it wasn't law. It was more.
Yeah, the other reason
you're talking about
the more political reason is they could be putting that along with the gay marriage. I mean, I think they're both based on the same Supreme Court precedent that is now a lot weaker now. But they could also be adding that too to make people basically vote on the record against. People who want to vote against it. You're voting against interracial marriage too. They could be doing that as well.
Oh, okay. Now I get it.
Yeah. That's.
I didn't get why they were together.
Yeah.
I was like, interracial marriage has been around. It's kind of accepted.
Yeah, but that's
no one really, at least law wise, it's kind of accepted.
Oh, sure.
That might be.
Yeah.
It's still an uphill battle for people. You know what I mean?
Yeah, I think that could be it too.
In some cases, you know what I mean?
I agree. Yeah.
Oh, well. Okay, thank you for explaining that.
No problem. Thanks for the call. I appreciate it.
Okay.
Bye.
Bye-bye.
All right, so what I'll do is I'm going to take a break. We'll talk a little bit about the bill that just passed the Senate that's going on to the House, and we'll take your calls too and your app chat messages, 508-996-0500. That's how you can get in the program. This is South Coast Tonight. I'm Marcus Farrow. Marcus, 508-996-0500 is how you can get in the program. We'll also take your messages on WBSM, on the WBSM app chat, which you can access if you have the WBSM app, which you should download if you haven't yet. So we were talking about the bill that the Senate just passed. It was a 61-36 vote. There were 12 Republican senators that had voted for it. And basically the bill is it's pretty narrow in its scope, right? So what it does is, and this, I suppose this is probably what they needed to get the 10 or so Republican senators that they needed in order to make this, passable, is it says that the federal government has to recognize marriages in states where marriages have been, if a marriage has been recognized by a state as legal, particularly in gay marriage or interracial marriage, then the federal government has to recognize it as well. This, because of its narrow tailoring, it doesn't prevent, which is unfortunate, it doesn't prevent, if the Supreme Court were to overturn the 2015 gay marriage case, doesn't prevent other states that may have anti-gay marriage laws in the books from blocking gay marriages, or I guess even making them void or voidable. Now, the 12, so that passed again 61-36. 12 Republican senators voted for it, and it's going back to the House for a final vote. It last passed in the House by a majority of like 50 votes, a 50 vote margin. So it's going to pass the House too, and then it'll get to President Biden's desk for him to sign it and make it law. It's not as probably sweeping as it should be. And for people who don't know the history, again, I talked about the 2015 case. Massachusetts was actually the first state to recognize gay marriage in the Goodrich decision. I think it's Commonwealth v. Goodrich in 2003. That was in 2003. And then 10 years later, you have the DOMA case that basically nullified the federal, the federal statute that recognized marriages between a man and a woman, and then that they gave a full gay marriage full legalization, basically full faith and credit everywhere else. I don't know what's going to happen if the Supreme Court overturns it, because you're going to have states where they're going to not recognize marriages if people want to move. Like, you say you get married in Massachusetts and you're a same-sex couple, and then you go to Texas, you have to. I'm just emailing somebody on a work-related matter. They could basically say, no, your marriage is invalid, not give you a marriage license, and then that'll jam you up, right? That'll definitely jam you up for a lot of reasons, tax things, and just recognizing certain, I think, fundamental rights, parental rights, all of that. I'm just sending an email. If you'll entertain me for a second, I'm just sending a work-related email while I'm on the air. Should I be doing this? Probably not. But sometimes you have to walk and chew gum at the same time. And that's what I'm doing now. So anyway, 508-996-0500. Tell you what, I'll take a break and we'll be right back. We'll continue this conversation.
Listen to us live anywhere in the world on the WBSM app. Real-time reaction to everything that happens after the sun goes down.
Going down till the sun comes up.
South Coast Tonight with Marcus and Chris is on WBSM.
Hey, welcome back to South Coast Tonight. I'm Marcus. 508-996-0500 is how you can get the program. We'll also take messages on the WBSM app chat. So we were talking about the, sorry, I had to send an email out, but we were talking about the law that was passed by the Senate that recognizes same-sex marriage federally in states that have recognized same-sex marriage. It's narrowly tailored, I think, because they needed those 12 Republican votes in order to get the majority that they needed, because essentially every vote in the Senate needs 60 votes because of the filibuster. And it also recognizes interracial marriage as well. And the reasoning behind that is that the Supreme Court has essentially has upended substantive due process, which is basically a legal precedent that a lot of fundamental civil rights laws or rulings were founded on, which, like Brown v. Board of Education and Loving v. Virginia, which is the 1967 Supreme Court, decision, and a lot of laws surrounding voting rights and all of that. Substantive due process is basically keeps the government from interfering with fundamental rights, even if they aren't specifically enumerated in federal law or in federal constitution. Allows the courts to recognize certain rights and do that. So it's difficult again, I've said this before. The Supreme Court in their decisions have said, well, we're not going to touch Brown v. Board of Education or Loving Virginia because we like those decisions, but you can't necessarily take their word for it. The Supreme and Clarence Thomas is invited essentially in his decision to for judges and lawyers to seek to overturn the 2015 Supreme Court law that overturns that made gay marriage the law of the land. So the 12 Republican senators, I think you can probably guess a few of them. Mitt Romney was one of them, former governor of Massachusetts. Mitt Romney, Susan Collins, Lisa Murkowski. They're kind of like the sort of to the extent that there is a moderate bloc, right? They are the moderate bloc. Like I said, to the extent that one actually exists in the Republican Party. But that isn't a surprise to me. Rob Portman is another one that's not a surprise to me. He's a senator from Ohio, the outgoing senator of Ohio. J.D. Vance will succeed him, the Republican author who wrote Hillbilly Elegy will succeed Rob Portman. But Rob Portman was always against gay marriage until he discovered his son was gay. And so he quickly came around, which, okay, I guess we'll take it. Maybe you should have empathy for people, whether or not they're directly related to you, but whatever. Fine. Thanks for your vote. Roy Blunt in Missouri, Cynthia Loomis in Wyoming, Shelley Moore Caputo in West Virginia, Dan Sullivan in Alaska. Dan Sullivan might be another one. It's kind of like maybe he's seeing, for some reason, Lisa Murkowski's always been a more moderate vote. And I think maybe it's because they might see a trend line in Alaska, right? Because of Mary Pallotta and her, winning the at-large seat for Congress, the Democrat beating Sarah Palin. Maybe they might see a trend line in Alaska that might be pointing to more moderate political positions. Or maybe they just think it's the right thing to do, but I just never assume that with senators. Joni Ernst in Iowa. Joni Ernst, I'm kind of surprised because Joni Ernst was the one that, I don't know, she's pretty conservative. She's the one that opened her campaign with her first campaign ad being about how she castrated hogs on a farm and that she would go to Washington to continue her profession of castrating hogs. That was 2014. Feels like forever ago. But 12 senators voted in the affirmative. I think they've got 50. They've got 50 Republican votes, 47 Republican votes in the House. So it looks like it's going to make its way to the House floor, and it's going to be the law of the land. Now, if the Supreme Court overturns the decision, you're going to see kind of a return to what we've always seen, which was what we saw before the Supreme Court cases from 2013 to 2015, which is some states recognizing gay marriage and others not, and having legal authority to do so. I mean, 2013, what they at least did was give gay marriage cases sort of full faith and credit by saying for the federal government, by saying if you are legally married in this state, then the federal government will recognize your marriage in another state. That doesn't necessarily mean that the state is going to recognize your marriage. And so you might see a lot of those situations. Remember that county clerk in Kentucky that went to prison because she wouldn't do her job and she'd basically deny gay marriage licenses, so they sent her to prison for basically not doing her job for a few days, and then she they had a big rally with Ted Cruz and a bunch of other people, and it was a whole big thing. But I think if the Supreme Court does overturn that, and they're inviting people to do so, that's important to remember. The one of the justices seems to believe that if they get that decision, they're going to vote the other way. That's why this act was necessary, at least in some respects, for these states. Then we're probably going to see, all of like the states like in New England, all 12 New England senators, obviously, including the one Republican, Susan Collins, voted in favor of it. So you're going to see states in New England, New York, Northeast, even the Pacific, along the Pacific coast, you're going to see them, recognize marriage equality, but in the Bible Belt, you probably won't, right? You probably won't in Alabama, Arkansas, etc., Louisiana, etc. It's, I think, a weird waste of political capital to do it, to do this. I mean, frankly, the trend line is pointing towards people being more acceptive. When Goodrich had been passed in like the early 2000s, 2003, the majority of the country was firmly against, I think, marriage equality, gay marriage in particular. They were firmly against it. And then around the time these Supreme Court decisions started coming out in 2030, it was like 30-something%, right? It's been a long haul. It's been a long haul. But around 2013-ish to 2015, they decided, well, why should we care about who people want to marry? Most normal people. Why would we care? And it's now like upwards of 60% who say that that this should, that gay marriage should be the law of the land. So the trend line's pointing there. I don't know why Republicans would want to do it. I think maybe to shore up a reliable voting base with the evangelicals. But it seems like, it's one of those things. You see the results, the election results in the midterms. They didn't win the House by as much as they should have. They didn't win the Senate, even though they probably should have. And I think a lot of it has to do with this, these sort of decisions. I think a lot of people are socially are going in the opposite direction of opposing this kind of stuff. And so, it makes sense for those 12 Republican senators, but frankly, it should have been 100-0. Should have been 100-0. I don't know why it wasn't. I don't even know why a law like this is even necessary in the first place, right? But it is. But it is necessary. It's not only necessary, it needs to be even broader in scope than it is right now. It's an unfortunate reality that we're still talking about it. You figure after 2015 it'd be settled. And for a lot of people, it is settled, Trump famously, he had Mike Pence as his VP, and he wasn't necessarily a friend to the LGBTQ community, but he did recognize gay marriage. So I don't think he cares either way, but they're at least going to get presidential nominees and candidates that if they want to win a national election, are not going to be against it. So the law is important. It shouldn't be necessary. All right, I got to take a break. We'll be right back.
The WBSM app is
From New Bedford, can you name one Republican in Congress who you respect? Said in the app chat message. I cannot. I'm sorry. Of the Republicans that I know that are in Congress, I can't. The list of Democrats is pretty short, too, to be fair. But one of the Republicans that I do respect is Charlie Baker. He's not in Congress, but I do respect him. And if he were to go to Congress, I'd respect him. There are Republicans here in Massachusetts that I do. In Congress, not so much. Frankly, the list of Democrats that I respect in Congress isn't all that great, isn't all that long either. So that's just kind of where I'm at, especially with Congress. So no, there isn't a Republican I can think of in Congress that I respect. If I do think of it, I'll let you know tomorrow. What I'll be in with Chris McCarthy, and we're going to have Robert Bromley, and we're going to have